Did you recently receive a denial in your Social Security disability case and you're wondering what to do next? My name is Caitlin Wildowner, and I'm an attorney who helps disabled clients obtain their disability benefits as quickly as possible so they can focus on getting better. Today, I will discuss the Social Security disability appeals process and what to expect. If your Social Security disability insurance or SSDI claim is denied, you can appeal the decision through a certain structured process within the agency. Number one, try to understand the denial that they sent. While it tends to be a form letter, the Social Security Administration does provide some reasons for the denial in the letter. Common reasons for denial include insufficient medical evidence, lack of work credits, earning above the substantial gainful activity limit, missing deadlines, or an incomplete application. You'll want to file the appeal promptly. You have 60 days from the date you receive the denial to request an appeal. This is worded as 60 days from the date of the denial plus 5 days for mailing. So technically it's 65 days. I usually recommend you want to try to file the appeal from 60 days from the date of the letter. So that way there's no questions asked. There are 4 levels of appeal. If your initial application is denied, you can file a request for reconsideration, which is a complete review of your claim by someone who wasn't involved in the initial decision. At that stage, you could submit additional medical evidence, work history, or other relevant documentation. If your request for reconsideration also results in a denial, you can request a hearing before an administrative law judge. The hearings are conducted by phone, by Microsoft Teams video conference, and in person. You will have the opportunity at that stage to update your medical evidence and provide testimony. The administrative law judge, or your attorney if you have one, may ask questions about your medical conditions and work limitations. If the administrative law judge denies your claim, you can file an appeal with the Appeals Council. The Appeals Council is going to review the ALJ's decision for legal errors or inconsistencies. The Appeals Council can outright reverse a denial and approve your claim. They can send the case back down for another hearing, or they can deny the request for review. As a matter of last resort, you can file a lawsuit in federal court if the Appeals Council denies your claim or declines to review it. At this stage, if you haven't already, you may want to consider hiring an attorney who's experienced in handling federal Social Security disability cases. In all stages, you want to gather strong evidence that supports your claim, such as updating medical records. You want to ensure all recent treatments, tests, and doctor's notes are included in your case. You may also want to request detailed letters from your healthcare providers that outline your limitations. Show how your disability prevents you from performing your past work as well as other work, not only in the medical records, but in the forms and testimony that happen at each stage of the claim. Number 5, you may want to consider hiring a Social Security disability attorney. They can help you navigate the appeals process, help you gather evidence, and represent you at hearings. Typically, the fees for an attorney are capped at 25% of the back pay, up to a maximum that's set by the Social Security Administration. Stay persistent. Many claims are denied, but appeals can often result in approvals if the medical record supports the claim. Be patient, as the process can take months and even years. If your SSDI claim is denied, act promptly, understand the appeals process, strengthen your evidence, and consider professional assistance to improve your chances of approval. Thanks so much for watching. If you're disabled and unable to work, click the scheduling link below or give us a call directly for a free consultation where we discuss your case and see what I can do to help you.